so much, and thanks very much for the invitation to address the committee. And I would also thank Julian for his fantastic background paper also. So indeed, I'm going to set the scene, I suppose, for the debate and throw out some arguments that indeed may be controversial, but I hope will provoke some debate. So I suppose the starting point here is indeed, as we've heard at the introduction, that the fact that for almost the past 2 decades now, the conventional wisdom for many competition regulators and scholars has, of course, been that competition law should be insulated from environmental concerns. And this narrative is by now a rather familiar one. The idea that competition law should be all about consumer welfare and maximizing economic efficiency, and that non-economic public policy goals, which include environmental concerns on that argument, cannot be taken into account. And so the argument goes, with the possible exception of state aid, that task should be a matter for the legislature rather than competition enforcers. And I think we see this kind of approach very clearly within the EU, for instance, in a number of Commission guidelines, in particular the 2004 guidelines on Article 1013 and the 2011 Horizontal Cooperation Guidelines. And indeed, the Commission, as was referred to in the introduction, is relooking at those at the moment and looking at this whole area. But I would argue that this approach is no longer fit for purpose and requires urgent change. Certainly within Europe, it's questionable whether the approach ever had any legitimate constitutional underpinning. And in my view, it certainly has none now. And I think matters have moved on significantly since the guidelines that I referenced. And this is so for a few reasons. So first of all, of course, now the environmental science is very clear. We all know that climate change poses an existential threat to the future of humanity. We know that globally we are in the middle of the 6th mass extinction of species. And indeed, as was referenced in the introduction, the evidence shows that these issues increasingly matter a great deal to consumers and therefore to businesses. But secondly, it's now beyond doubt, I think, that private environmental initiatives must, in order for environmental policy to be effective, play a significant role in the policy mix. And we can see this every day. We think, for instance, of the Forest Stewardship Council, the Marine Stewardship Council, the first mover supermarkets that choose to ban single-use plastics, the carbon divestiture movement, for instance. And such initiatives are based on the profound realization that it is no longer good enough to sit back and wait for the legislature to act. And there are many reasons, of course, why state action may not always be effective or as effective as private action. Environmental problems do not respect jurisdictional borders. They are in many cases caused and may most effectively be solved by transnational economic actors. And the state may not always have the expertise to know what the most effective environmental solution is for a specific industry. And even if it does, it may not be able to act and react as speedily as private actors at the economic coalface can. And within Europe, this all-economy approach to environmental degradation is, of course, central to the European Green Deal, which has been described as the European man on the move moment by President von der Leyen. And as corporations' power as environmental actors is being recognized, so too are their responsibilities. We can think, for instance, of the wave of climate litigation that is currently underway in jurisdictions such as the US, in Germany, Poland, for instance. And I think we have to ask ourselves whether we, as competition professionals, are prepared to accept that such corporations may reasonably argue that they were dissuaded from vital collective action due to the risk of competition enforcement. And I would suggest the answer to this question should be a resounding no. In my view, there is no convincing justification for the a priori exclusion of environmental benefits from the competition assessment. And as Julian's paper highlights, The laws of many states now recognise the special legal importance of environmental protection. And within the EU, this exclusion, in my view, contravenes the obligation that we have in Article 11 of the TFEU and Article 37 of the EU Charter of Fundamental Rights to integrate environmental protection into all other EU policy areas. And it is striking, I think, that nothing in the EU court's case law, for instance, has ever supported such an exclusion. And I would suggest that that indeed is unsurprising. Judges, I would suggest, do not think in legal silos and prefer rather to view the legal system as a cohesive whole. And courts are well used to balancing competing interests. For instance, in the EU, they typically apply a proportionality-based analysis to do so. And so I would suggest that the exclusion of environmental considerations by competition enforcers in itself represents a normative choice, which is, at least in the EU, not supported by any legal mandate. So finally, I don't think this requires a fundamental rethink of the approach to policy factors in the competition analysis. In my view, and we'll discuss this further today, the consumer welfare standard is perfectly capable of accommodating environmental benefits. Methods of quantifying environmental benefits, such as, for instance, assessment of consumers' willingness to pay for better environmental quality, are well established now in environmental economics. Of course, arguments may be had as to how they should best apply in a specific case, but I would argue this is also true for many fields of competition economics. So I would suggest that a case-by-case approach will be required, ensuring that environmental aims are not used as a pretext for collusion. So just to finish off, I think, of course, there are significant challenges here, but I would suggest that climate emergency requires innovation from competition authorities no less than the rest of society. Policy leadership is required. And in reference to the questions raised at the outset, I would argue that the argument should no longer be about whether environmental benefits can be considered in competition analysis, but rather how they should be considered. And so I would respectfully invite competition authorities to send a clear signal to industry that competition policy will not stand in the way of genuine and proportionate pro-environmental initiatives. Thank you, Chair.